in session. You may be seated.
Mr. Watson, you can proceed. You may proceed. Thank you.
Lawrence Watson, appearing pro se. Just for the record, I'd like to state that I object to any justice of this court hearing any matters, this matter or any other matters that I bring to the highest court of the state. Under SJC-10540, I believe Canon 3 and Title 18 USC 655 or 654, if I'm not mistaken, a judge of the court is supposed to disqualify themselves from a proceeding if their impartiality is questioned. I think any individual that, any impartial individual that will review the matters I've had before every justice of this court.
So then who would hear your cases?
If I'm not mistaken, I guess a panel from the appeals court would have to be assembled to hear my cases.
We don't have that. We don't have that practice,
I'm
Mr.
just
Watson.
putting that as an objection for the record. Didn't expect you to act on it. The respondent justices committed perjury and fraud in their decision of what I cited as docket 1274, which was my appeal of, again, cited in my document, docket 378 from Dorchester District Court. A review of the decision will show that it's inaccurate and I would argue blatant acts of perjury when you compare their decision based on the information provided to them. In the decision, they stated that Sherry Walker, the mother of my only daughter, filed for a restraining order against me under Chapter 209A in Dorchester District Court on May 5th. What it failed to, their decision failed to include was that in April of April 16th of 2003, I obtained a restraining order under Chapter 209A in the Suffolk Probate Court against Sherry Walker, and despite the fact that she failed to appear, the order wasn't extended, and there was a police report on the matter for which the Boston Police Department requested an evidentiary hearing for a criminal complaint. It also does not discuss that when Sherry Walker applied for the restraining order, she failed to comply with Section 3 of 209A by listing on her application that she was previously a defendant in a 209A proceeding I had against her. In the decision, the judges state that I refused to, I elected not to appeal the extension of the initial order on May 19th. Again, what they failed to state is that the documents show that on 2 occasions I requested a hearing earlier than 10 days in accordance with Section 4 of Chapter 209A. The use of the preposition within means less than, equal to or less than 10 business days of the court. The clerk of that court, Clerk Leslie Martinez, refused to allow me to reschedule the matter because by coincidence I had a unrelated appearance in Taunton District Court on that same day. The transcript of that hearing on May 19th will show that Justice Miller was aware of it. She had received the motion for a new hearing as well as motion for a change of venue, and she refused. In the transcript it states that Justice Miller said, well, he can come later and tell his side of the story, which there are numerous cases from this court will say that violates due process rights. I have the right to face my accuser, and that's in Chapter 209, Section 3. So then the decision from the justices then states that I filed a motion to dismiss, which was accurate, and that it was denied. What, again, their decision does not state is that I filed a motion to dismiss. Justice Timothy Galey violated my due process rights because he changed it from a motion to dismiss to a motion for an extension, and then he extended the order a year from the date before him. There are several cases, as well as stated in Chapter 209A, after the initial extension, after the issuance of an ex parte order, the first extension can be no longer than 1 year. By Justice Galey extending it 1 year from the date before him, he gave it the order 13 months, a lifespan of 13 months. In the decision, again, if you review the documents of the that show the chronological order of docket 378, the justices stated that it was continued for a year. for 6 months, which was inaccurate because it was extended by Justice Galey on June 18th, 2003, for a year. Clerk Leslie Martinez refused to allow me to file a notice of appeal for that decision. I appealed to court again on Dorchester District Court on June 18th, 2004, at which point Justice James Coffey extended it for 6 months. And the justice refused to address that issue because it's been stated on several occasions that the continuance of a extension of a restraining order in 209A is not automatic. There has to be a continued need for concern about imminent fear or harm. And in June 18, 2004, as well as December 16, 2004, under cross-examination, Sherry Walker admitted there was no interaction between herself and me other than proceedings in the court related to the child custody matter. At that point, the justice then said the order was extended from December 16, 2004 to December 16, 2005. In their document, they say, in the footnotes, it notes that after 3 years, the district court finally assembled the record and sent it to the appeals court, which was an issue that came up here before. In that matter, the matter was dismissed under Standard Rule 17A because the Dorchester District Court refused to give me documents for when we create a record. And since 2004, I have been unable to obtain a court tape to make a transcript, which is also documented in docket 1274 before the appeals court justices. And then in their document they said in December 15, 2006, myself and Sherry Walker appeared in Dorchester District Court before Justice Coyne, which was accurate, but what it fails to address is that Justice Coyne refused to allow me to cross-examine Sherry Walker for new allegations, and the affidavit was included in the brief before the appeals court. I specifically asked 4 times to cross-examine because I was aware of a case, CO versus MM, in which this court determined that a defendant is entitled to cross-examine a plaintiff in the 209A proceeding, and he refused to do that. I asked for written specific findings stating Santosky versus Kramer because for the 3 years that the restraining order was continually extended, it contained a provision that denied me access to my daughter. Now, without arguing the veracity of Ms. Walker's statements, she never stated that I did any harm to my daughter. And there are a long line of cases in the U.S. Supreme Court that say, unless there's a determination of parental unfitness or fear of imminent harm, the state cannot interrupt the child-parent relationship. Now, this has been going on since 1995, this harassment by state officers. It started in Dorchester District Court, and the acts by the appeals court justice is just one of the latest incidents. And citing City of Cleburne versus Cleburne Living Center, as well as the Squaw Valley Development, the U.S. Supreme Court has determined that there can be a class of 1 equal rights and due process claim, and I believe that is the case that I have. Merely violating state statute does not establish it, but the intent is. And the intent has been, since 1995, to squash my opposition to unjust, the discriminatory practices of the Commonwealth in the issues of 209A, and specifically the violation of the state laws in the issues of restraining orders against myself. My argument is that this act by the appeals court justices is violating my substantive due process rights because it shocks the conscience. Now, most of the cases in the Supreme Court, when they say shock the conscience, they usually refer to cases that involve intrusion upon the body, such as forced enemas or stomach pumping. But in Grindle versus Gilway, because of the situation where a police officer threatened a gentleman, an individual's child, that was considered shocking the conscience because of the interruption and the irreparable harm to the parent-child relationship. And I think my case mirrors this case. If not, it's even worse because my daughter turned 7 December of 2009, as a direct result of these justices and several other justices in the Commonwealth, I haven't seen my daughter since she was 7 months old.
I thought the revised order gave you access to her visitation.
No, what happened is the order was issued May 19th. A judge in probate court, Justice Lee Moriarty, on May 14th, said that depending on a drug test, because there were mutual allegations of drugs, I passed, Ms. Walker failed. Ms. Walker was to take my daughter to my mother's house across the street, less than 30 feet. She did it twice and refused to do so after that. I went to Justice Moriarty and told her what happened. And my mother didn't want to be involved in the procedure no more, plus she felt that it would force the court's hand to allow me to have my parental rights. And I haven't seen my daughter since.
Okay.
But in close, I'll just argue that I believe I have every right to come to this court. I mean, I attempted to ask for further appellate review after the actions of the judges. This court denied me. But as I cited in the case Commonwealth v. Amaral, this court said that in the case of judicial abuse of power, the public has the right to expect this court to do something. And that's what I've been trying to do for the past 5-6 years. I cited at the end Goss v. Illinois because I'm asking this court to take whatever steps to initiate an investigation, whether they have to go federally or get a special prosecutor to investigate the violation of my rights. Like I said, I haven't seen my daughter in 7 years. Is preceding this issue, but I haven't had my gun license in 15 years. I just recently had everything I had personally destroyed. So this is harassment. And as I said, in Goss v. Illinois.
Mr. Watson,
Yes.
I think you've been here enough times to know what the flashing red light means, and I usually let you in closing, but your closing is now going on to other arguments.
Oh, I'm sorry. I was looking at the countdown. I thought it was going like how much time I had left.
No, that's how much time you've gone over.
Well, this is the close. I would just ask that, again, citing Goss v. Illinois, the U.S. Supreme Court stressed the limitations that the federal government can do as far as intervening in judicial proceedings, state judicial proceedings, but it emphasized that state judges as well as federal judges have a responsibility to protect the constitutional rights of individuals, and that's what I'm asking this court to do. The failure to do anything to these judges is violate my constitutional rights under Article 3 of the U.S. Constitution and Article 5 of the Master Declaration of Rights.
Thank you, Mr. Watson.
Thank you.